out there, honey. Come on. I know.
September 27th, 2020, 28-year-old Ashley Benefield runs to a neighbor's house after shooting her estranged husband, Doug, in her bedroom.
She came in. She was quite hysterical. I didn't know who was banging on my door. Said that he attacked her, and she shot him.
Doug Benefield was 30 years older than Ashley and a widower when they met in 2016. They quickly married after a whirlwind 13-day courtship.
I first heard about Ashley, it was a Friday after school. The next day I met her, and then the following day, it was a Sunday, he told me that they were actually married, not just dating.
Ashley was a former ballerina, and she and Doug founded a ballet company in Charleston, South Carolina, to train and to showcase new talent.
He was completely in love, completely supportive, starstruck.
But by the end of 2017, the ballet company was bankrupt. She was pregnant, and their marriage was falling apart. Ashley left Charleston and moved to Florida to live with her mother because of her morning sickness.
I was unable to take care of myself in any way. I was completely, I would say, bedridden.
Ashley was due in April of 2018. Doug had followed her to Florida, but she wasn't speaking to him. And he hired an attorney to try to help him find out if he could be with her for the birth.
To your knowledge, was Doug there?
No, he was not there. He had no idea the baby was born.
After their daughter was born, Ashley filed an injunction to try to keep Doug from seeing her. She claimed he had a history of violent behavior and accused him of poisoning her and their unborn child.
I believe he tried to harm my child while I was pregnant with her, and that leads me to believe that if he would try to end her life or harm her while she was in utero.
The motion was denied, and the family court judge blasted Ashley's claims that Doug had poisoned her.
There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison.
Over the next 2 years, Ashley appealed the court's decision and continued making allegations of abuse against Doug. They were both ordered to undergo psychological evaluations, the results of which were scheduled to be released 3 days after Doug was killed.
It is the state's contention that the defendant did not want this report to come out. It was not positive towards her. Her goal was to move to Maryland and start over with DCF and the police up there, and maybe someone would believe her.
The day he was killed, Doug was at Ashley's home to help her pack up a U-Haul for her move to Maryland. He was unarmed when he was shot twice, once in the leg and once in the chest. Ashley says she was acting in self-defense after Doug body-checked her 2 times, hit her with a box, and grabbed her arm.
Given what she knew on that day about Douglas Benefield, boy, did she have every reason to fear him, especially after he refused to let her leave her own home.
Ashley Benefield is charged with second-degree murder and could be sentenced to up to life in prison if she's convicted.
The Black Swan murder trial. It will be happening soon. You will see it right here on Court TV. Let's talk about it. Al Wunsch, Darnell Cross, and Jennifer Brand, our think tank, still with us tonight. Darnell, she's claiming self-defense. She's claiming that he is the aggressor in all of this. She didn't do that well in family court. Judge didn't buy her story, didn't buy her testimony about being poisoned. Will a jury, you think, buy her story about being a victim?
It's kind of tough when you see a sort of a track record of self-help and it's connected to a goal. And that goal is to have that child with her and her only. And then everything else that you see that surrounds that goal is going to be looked at with, questioning eyes. So in the family court, the judge said there was no scintilla evidence that you ever poisoned. You didn't go to the hospital. You didn't have a history of anything medically that shows that you were poisoned. It sounds like you're just trying to support this goal of why you're here in family court. Then you take it over to criminal court, and what is he doing helping her move or pack or whatever? It sounded like she agreed to that so he can get over there and then she can carry out this murder. So nothing adds up, and if it didn't add up in family court, the burden is even higher in criminal court, and so I don't see the self-defense claim working.
Jennifer Brandt, we know things get heated when a couple is breaking up. We know they get more heated when they're fighting over the custody of a young child. And in this case, you had a woman who left where they lived, who went to go live with her mom. Now, obviously, it seems there's probably be two versions of why all this is happening. Who is the dangerous one? Who isn't the dangerous one? Let me ask you, from your experience in family courts, how difficult is it in these situations to uncover the truth of, like, who, like we saw it in the Johnny Depp Amber Heard case, right? We saw how that all played out. This is sort of a similar scenario that turns deadly in that there was obvious problems between these two, but how tough is it to figure out who's the aggressor, who is the dangerous one, and who isn't?
Very tough, Vinny, because it is a he said, she said. You know, you don't have a lot of third-party witnesses often in these types of cases because it involves a time period, you know, of what went on in the relationship and, you know, different events that may have occurred. It's not just one single event necessarily. But I think what hurts her here are the claims that she made in family court about him poisoning her, and the fact that the judge found that there was no evidence whatsoever to support her claim. So it makes anything she says now come into question, including the self-defense claim that she's raising as the reason why she shot him. You know, without that, without the issue of the poisoning, then maybe, you know, she would have a bit more credibility because she did have some bruising on her or scratches or whatever. But the fact that she tried this once, tried to get him away from the child, and then comes up with this self-defense claim, I just think it sounds pretty weak. I think she wanted to have that child. I agree with Darnell, and she didn't want him part of her life. And that happens very frequently in family court. You know, one party just doesn't want anything to do with the other one and doesn't want them to share custody of the child. So that's pretty common.
Al, the closest we have to an eyewitness to this is the neighbor who called 911. So he doesn't see what actually happened, but he's there in the immediate aftermath of all of it. And it's clear to me that he is very sympathetic towards Ashley Benefield, the defendant here. My guess is the defense will likely call him as a witness. Prosecution may call him as a witness. He called 911. But how important is the 911 neighbor to all of this? Someone who's living next door to them, who, again, very sympathetic to the defendant in this case.
Well, see, the problem is like, I don't think he has any firsthand knowledge of anything. And I think, quite candidly, he's taking what she says and then going forward with it. I mean, you can hear her kind of hysterical and things along those lines. And then he throws out that comment, well, they've been having problems, like maybe paraphrasing it, or they've been having trouble or something along those lines. And we don't know where he gets that from. We don't know if he saw that or that's what she told him. So I don't know how good of a witness he's going to be, other than the fact that she came over there hysterical and this, that, the other thing. But as I remember, the Menendez brothers did a pretty good job of being hysterical on the phone and screaming and yelling and everything along those lines. And they were convicted of the murder of their parents. So I'm not sure that he really adds anything to this case. And like, you know, what was mentioned before, you know, by Jennifer and Darnell, I mean, the hurdle to get over to convict someone in domestic violence courts is preponderance of the evidence. And the judge found that she didn't even have a scintilla of evidence. So the credibility is zero. I mean, a scintilla is the smallest, slightest amount of credibility, and she didn't even have that. So I think it's going to be a very big uphill battle for her as a defendant in this case. And obviously, she's going to have to take the stand. And if she couldn't convince the domestic violence judge that there was a case here, I think she's going to have a hard time with the jury.
Well, let me ask you this, Darnell. We only have about 30 seconds here. Being a swimsuit model and a ballerina, is that an advantage or a disadvantage when you're sitting in the courtroom as an accused murderer?
Well, there was one judge in the Bronx Criminal Court that during the jury selection, the defense attorney was striking a lot of people, and then this beautiful woman came up, and the judge leaned over to both of them and said, if anyone strikes her, they're going to have a problem with me. So I think it's an advantage. It helps court the day go by quicker.
All right, stay where you are. When we come back, we're going to take you into family court and what happened there and what happened today at a hearing involving some evidence. Should it come in? Should it not come in? There he is, Neil Taylor, a really good attorney representing the so-called Black Swan, Ashley Benefield. She's been charged with murder, and he's trying to keep some evidence out of the case. It's pretty normal. Motion to suppress some of the evidence, keep it out. Motion to eliminate, can't have it. So one of the big pieces of evidence is really just a scintilla of evidence. A ruling by the judge that there was not one scintilla of evidence of this alleged poisoning. Let's take a listen to that ruling, which was made in the family court matter.
This court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Miss Benefield.
Ouch. Ouch. So obviously the defense does not want the recording of this hearing in front of the jury in the murder trial and was arguing against it today.
This is a recording that takes place, Judge White, 2 years before the actual homicide. And in a nutshell, Your Honor, they've advanced this theory by weaving innuendo and inference, and you just cannot make a fact out of that, Your Honor. So with no respect for the magnitude of the leap, the state basically says, well, when Ashley Benefield heard Judge Moreland opine about her credibility, that was when she decided to kill Douglas Benefield. That's a pretty high leap from going to having to share custody with a child to deciding to kill the spouse. We're basically saying to the jurors, here is the opinion of the chief judge of this circuit, who has concluded that Ashley Benefield, under no circumstances, has one scintilla of credibility, that she would not believe anything Ashley Benefield has to say. Ladies and gentlemen, you don't have to attach any significance to that other than the impact that it had on Ashley Benefield. The problem with that is they're hearing the opinion of the chief judge that sits in this circuit. And the case law is replete with references to the influence that such a statement from a judge would have, much less the chief judge.
Jennifer Brandt, it would be very beneficial to the prosecution. What do you think? Is it fair for the jury to hear that a judge who listened to her testify found that there was not one scintilla of credibility to her story about being poisoned?
I do, because I think it's about the claim that she was advancing. The fact that, you know, Doug had poisoned her and he was, you know, be kept away from her and tried to harm her and their unborn child at the time. So I think it's all very related to what is going on here and the claims made in this case, in the criminal case. So I do think it's important for the jury to understand that another judge totally rejected her claims and that she was clearly trying to build a case against him, trying to show that he was, you know, a bad guy and was out to hurt her and he should have no contact with their child because of that. So I do think it's very relevant in this case because it shows why maybe why she's being charged and why she might be found guilty of the crime that she's charged with, that she actually shot him just to get rid of him, as opposed to self-defense.
Al, how do you think this plays during the trial? Does it get played during the trial?
I think it has to get played. False in one, false in all. And under these circumstances, I mean, she made some very serious allegations against him. One, that not only he was poisoning her, but he also poisoned his wife, and that she ended up dying as a result of what he did.
His first wife. His first wife.
The first wife, right?
Yeah.
The first wife. And that the police investigated that, and it turned out it was not credible, and that it was not accurate, and it wasn't true. So, the fact that she has gone this route, and then the fact that the kid is born basically isolated from him, doesn't put his name on the birth certificate, everything along those lines, just shows that she has a plan. She wants him out of the picture, and it progressed. If I can't get him out by accusing him of murder or attempted murder or anything along those lines, then I have to go to the next level, which is self-defense. I'll kill him. Simple.
Darnell, I want you to take a listen to testimony from a psychologist who evaluated Ashley Benefield. And this, again, is something that the defense wants excluded from the murder trial.
She made it very clear on more than one occasion that she had no intention of reconciling with Doug, and that she had every intention of relocating to Maryland with her mother, and particularly because her grandmother had passed away and her mother had inherited that home so she could return to her native home state of Maryland.
And did she indicate to you that she was going to go without Doug? Go to Maryland without Doug?
Again, in several different occasions, she had indicated that was her intention. She did not want him to come along with her. There was some email exchanges indicating that she was trying to make that happen. He made it clear that he was going to be going there and thought that he'd be moving in with them, which she clearly made clear to me that that was not going to happen.
Okay. So she made clear to you that he is not moving in, we are not getting back together.
Yeah, absolutely.
Did she say those things and act that way during the joint session with Doug?
No.
Okay, Darnell, so should the jury hear this? Should the jury not hear it? And again, the theory of the prosecution is that she was telling Doug that they were going to reconcile, and that's why he's with her and trying to get that done, when really having no intention to ever reconcile with him.
Well, yeah, so there's a distinction between this and the idea that a judge made a determination in another hearing dealing with other issues versus here. So in this particular evidence, I would say, yes, this can come in, because as legal scholars, we have to ask ourselves, why are we letting something in? Why are we talking about this? In this particular case, it goes directly to motive. So if obviously she's trying to claim they were getting together, they were trying to reconcile, and then she's claiming that's when this meeting took place and she killed him because he tried to hurt her. That's evidence. Whether you believe it or not, that's evidence. In the other situation that we talked about, relevant evidence is important. Evidence having a tendency to make the existence of a fact that's in consequence more probable than not. Judges get appealed all the time for making wrong decisions. Now, it might be helpful, but it's not relevant, and it's not relevant evidence. A judge's conclusion is not evidence, and a jury should be able to listen to something de novo and not have to listen to something already concluded by another court and say, okay, the other court said it, so it's true. So I don't think it's false for one, false for all in many instances. You have to take them separately.
Let me ask you, Jennifer Brandt, when it comes down, it's self-defense. I believe she's going to have to testify in this one. In terms of jurors, men versus women with the swimsuit model ballerina on trial, how does that play?
Yeah, I think she wants a bunch of men on that jury, because they may feel sorry for her. They may feel that, she's beautiful and innocent, and she was much younger than he was. And that she was just being, he was harming her, and she had defend herself, and that's why she shot him. I think she has a much better chance with men on the jury than women. Women will be more skeptical of her and probably say, you know, they would not necessarily believe what she has to say. But
Al, do you concur?
I don't, actually. I think men are going to be very critical of a woman taking their daughter away from them. And I think that men are going to look at that and say, wait a minute, why did that happen? And that I would do anything to stay with my child. And that she stood between them and tried to alienate him out of the picture. But he didn't see the baby for 6 months after the baby was born. And I think a man that is sitting on the jury is going to look at that and say, there's something wrong here. There's something that doesn't click quite right, and that it's going to come back and backfire on her. I think she's got a better shot with women on the jury.
Darnell, you have 5 seconds.
Yeah, my experience supports Jennifer because men typically are rescuers, and women are typically more critical. In the sexual assault cases, you find that. So I'm going to go 2-1. Jen and I, we win. Al loses.
There you go. Al Wunsch, Darnell Crossland, Jennifer Brandt. That's all the time we have. We'll see you next time.